Hello, my name is Borg Barthet, and over the next 20 minutes or so I will present a very brief introduction to EU company law. Now, when we talk about European company law, we're actually talking about three different, quite distinct topics. EU company law could refer to the law that regulates supranational business vehicles, that is to say, companies that are established in part by EU law. It could also refer to a separate subject, which is the EU directives that harmonize national company laws of the member states. Thirdly, EU company law is also concerned with the mobility of companies, with freedom of establishment for companies as a consequence of Articles 49 and 54 of the Treaty on the Functioning of the European Union. I'll address all three of these topics in turn during this brief presentation, but I'll focus principally on the third of these topics, namely the mobility of companies. So to begin with, we'll address very briefly supranational business vehicles. Now, the reason why supranational business vehicles are going to be addressed so briefly is because in practice they aren't actually particularly important at present. The Societas Europaea, that is to say the European company, was established by Regulation 2157 of 2001 and is regulated in part by that regulation and in part by the national laws of the member states. Now, the reason why the Societas Europaea isn't a particularly useful instrument to most businesses, and in fact has not been taken up by many companies, is because it is so expensive to establish this type of company due to minimum capital requirements that are quite onerous, and also because the Societas Europaea does not resolve problems concerning corporate mobility, that is the ability of a company to change the situation of its headquarters or to change its governing law without restriction. Now, in order to resolve some of the problems concerning the Societas Europaea and to establish a more accessible business vehicle also for smaller enterprises, it was proposed to establish a Societas Privata Europaea. And this proposed business vehicle was intended to provide a low-cost alternative to the Societas Europaea, also having the EU brand and therefore being possibly more marketable internationally. However, the negotiations leading to the adoption of this instrument have been stalled for some time due to disagreement between the member states concerning employee participation in this business vehicle and also the rules concerning the mobility of the Societas Privata Europaea. So for the moment, the only supranational business vehicle available, or the only supranational company available to promoters of companies in the European Union is the Societas Europaea, which, as I've just said, is quite expensive and suffers from problems concerning restricted mobility. So I'll move on quite quickly from this topic to the harmonization of national laws. Now, the legal basis for harmonization is to be found in Article 50 of the Treaty on the Functioning of the European Union. And that article provides that the Parliament and the Council can adopt directives to coordinate safeguards for the protection of members and other stakeholders of companies. And the reason for this is to establish minimum safeguards in the laws of all of the member states. So what has actually been achieved to date? Well, several directives have been adopted concerning, among other things, publicity requirements, minimum capital requirements. In certain companies, of a union-wide dimension, of a community scale. Employee consultation is required. In certain companies, that is listed companies, there are minimum standards of shareholder protection. And then there is another type of directive concerning mobility, that is the cross-border merger directive. Now, the cross-border merger directive is, in a sense, one of the more revolutionary directives in that it allows companies from one member state to merge with companies from other member states. And it includes in its provisions rules concerning the protection of shareholders, the protection of creditors, and possibly employees, depending on the relevant national laws. Now, the first four categories of directives that I've mentioned have harmonized national laws to a significant extent, but they have been described as trivial by some commentators because they haven't actually changed the core features of national company law. The efforts to harmonize these features, such as the structure of the board of directors, have in fact failed because the member states failed to agree on the basic features of company law. So we still have quite diverse views among the member states concerning basic governance structures, such as the role of employees in companies and whether a company should have a single board or a two-tier board. So while the directives have established a minimum of harmonization, they haven't actually made all companies in the member states particularly similar in certain important respects. Which then leads us to the next topic concerning the mobility of companies. Now, when we talk about the mobility of companies, we're not simply talking about a company's ability to move from one state to another. Effectively, we're talking about choice of law. We're talking about the ability of an entrepreneur to choose which law will govern that company. And because, as we saw in the previous slide, the core features of company law are not the same throughout the European Union, the ability to choose a law is very important to entrepreneurs. Now, when we discuss this topic, the main sources that we need to be aware of are Articles 49 and 54 of the Treaty on the Functioning of the European Union and the judgments of the Court of Justice. But before we address these sources of law, I'll first attempt to clarify what we mean by corporate mobility. There are two types of corporate mobility. The first is de facto mobility, which occurs where a company changes the physical location of its headquarters. That is to say, it is an actual physical move by a company from one state to another. And this can be done either with a change of the governing law, so it could be a choice of law accompanied by a physical move, or it could simply be a physical move. On the other hand, you can have simply de jure mobility, which is simply a change in the governing law. There isn't any actual physical movement, or there isn't necessarily any actual physical movement, but a company will change its nationality, its domicile, and become governed by another national law. Now, in principle, this can happen with or without a change in the physical location of the company's headquarters. So, de facto mobility, in principle, can happen without a change in the governing law. De jure mobility can, in principle, occur without a change in the physical seat of a company. In practice, however, there is a quite different story, which we'll address in a little while. Now, coming back to the law for a moment, Article 49 and Article 54 of the Treaty on the Functioning of the European Union seem to suggest that there shouldn't be restrictions to the mobility of companies. Article 49 of the treaty provides that nationals of the member states will benefit from freedom of establishment, and this freedom of establishment is then extended to certain companies under Article 54 of the treaty. Now, in order to benefit from freedom of establishment, it appears from Article 54 that companies should be formed under the law of a member state and have either their registered office, their central administration, or their principal place of business within the Union. If a company satisfies those requirements in Article 54, it appears that they should benefit from freedom of establishment. Now, up to here, things appear quite simple. But matters get a little bit complicated when we consider that there existed previously Article 293 of the EC Treaty, which provided that matters concerning the mobility of companies, as defined in Article 54, will, so far as is necessary, be subject to a future legal instrument agreed by the member states. So Article 293 provided that the member states shall, so far as is necessary, enter into negotiations with a view to securing the mutual recognition of companies and the retention of legal personality in the event of a seat transfer. Now, the member states adopted a convention in 1968 concerning the mutual recognition of companies, but it wasn't ratified by the Netherlands. So what happened effectively from 1968 onwards was that there was an expectation that corporate mobility would be subject to the adoption of a future instrument. And therefore the member states retained their different approaches to the recognition of companies and to the mobility of companies. The member states had different views concerning recognition of companies, that is to say, the conditions under which a company established under the laws of one state will be recognized as a separate legal person by the laws of another state. Most of the member states adopted the real seat theory. And examples of these types of state include most states of the civil law tradition, including Germany, Austria, France, and Spain. Now, the real seat theory provides that companies must be established under the laws of the state in which their operational headquarters are situated. So if a company has its headquarters in Germany, that company must be governed by German law. It cannot choose the law of another state. By the same measure, in France, if a company was established with its headquarters in France, it could not be governed by any law other than French law. If it did choose to be governed by another law, it wouldn't be recognized in France, which would of course be significantly problematic for representatives of that company, because they would expose themselves to unlimited liability. Now, the rationale underpinning the real seat theory is that companies are viewed as concessions of the state. That is to say, a company cannot be established except with the intervention of the state, and therefore the governance arrangements within that company, the balance between the several interests in that company, would be established by the law with which that company is most intimately connected. And the view was taken that the closest connection was between a state and the law of the place where its headquarters are situated. So that is the real seat theory approach, which is to be contrasted with the second approach adopted by, among others, the United Kingdom, the Netherlands, Denmark, and Malta. And this other approach is called the incorporation theory. Now, under the incorporation theory, companies are governed by the law of the state in which they are incorporated. And there is no need for the company to have its headquarters in the state in which it is incorporated. Now, the rationale for this approach to the establishment of companies and recognition of companies is that companies are principally creatures of contract. They are principally the product of a private agreement which is then endorsed by the state. And in contractual theory, the view is taken that we should be free to choose both the content of our contract and the law governing that contract. And extended to corporate law, the view is taken that promoters of companies should be free to choose the law that governs their company. So the real estate theory favors a close connection between the state and a company, whereas the incorporation theory is more inclined to respect the contractual arrangements made by the parties. Now, of course, there are merits and criticisms to both approaches, which we won't really have time to go into now, but what's important to note at this stage is that there are very different approaches to the recognition of companies, which are effectively seated in different views concerning company law itself. So real estate theory states tend to adopt a more restrictive, more regulatory approach to companies, and therefore tend to protect stakeholders other than shareholders to a greater extent. So you'll see, for example, in Germany, one of the more developed forms of employee participation. On the other hand, incorporation states, such as the United Kingdom, the Netherlands, Malta, favor a contractual approach and tend to have a more accommodating company law, which is, of course, more attractive to promoters of companies. So then, this leads us quite clearly to the next slide, in which we consider what are the issues concerning mobility. Why has the mobility of companies been such a problem? Now, in the left panel, there are some reasons why member states seek to restrict corporate mobility. The first reason is fiscal, tax reasons. Member states, of course, tax companies and benefits from corporate fees, and they are obviously inclined to wish to maximize their income from companies, and therefore might restrict corporate mobility for these reasons. And what we'll see as we go on is that this is true of states that adopt the real estate theory, but it's also true of states that adopt the incorporation theory, the more contractual approach to companies. Now, equally, there could also be corporate policy reasons for restricting mobility. As I said when we were discussing the previous slide concerning the different theoretical approaches to recognition, mobility might be restricted because states which wish to protect their particular construct of companies, and therefore they do not wish that companies established in their territory should be governed by a different type of company law. On the other hand, there are, of course, strong policy reasons for mobility. First of all, there is the sort of European integrationist ideal of the establishment of an internal market which is free of artificial distortions. That is to say that entrepreneurs throughout the Union should have access to the same business vehicles in order for them to benefit from the same efficiencies. Another reason is, of course, associated with the interests of entrepreneurs. So while member states would wish to restrict mobility for fiscal and corporate policy reasons, entrepreneurs would wish to benefit from mobility to avoid stringent fiscal regimes and to avoid corporate laws which render entrepreneurs subject to obligations towards other stakeholders. So these are the interests in corporate mobility, and we'll see going forward how the Court of Justice of the European Union has dealt with these matters in the context of the laws which we discussed previously, effectively Articles 49 and 54 of the Treaty on the Functioning of the European Union, and Article 293 of the EC Treaty, which has now been repealed by the Treaty of Lisbon. Now the first case that we're going to discuss is the case of Daily Mail, case 8187. Now the facts in this case were basically that Daily Mail, which was a UK company, wished to transfer its residence to the Netherlands. And the reason it wished to do this was to benefit from a more beneficial tax regime. Now, in order to transfer its residence to the Netherlands while retaining its its status as a UK company, Daily Mail required permission from the Treasury, and of course permission could be refused by the Treasury. So Daily Mail wished to embark on a de facto transfer of its seat. So this is de facto mobility we're dealing with here, without de jure mobility. Daily Mail did not wish to change its governing law. Now the Court of Justice in this case, mindful of Article 293 of the EC Treaty, which granted the member states the ability to adopt legislation concerning the transfer of a company's seat, the court concluded that the treaty did not resolve this matter, that this remained a matter for the member states. So the court held that the transfer of the registered office or head office of a company incorporated under national law was a problem which was not resolved by the rules concerning the right of establishment, but one that was to be dealt with by future legislation. Now, people who supported the real seat theory were very happy with this judgment, whereas others who had a more either pro-business or pro-European integration agenda considered this to be a disastrous judgment that endangered the internal market project. But the judgment did stand for a long time, and in many ways it still stands. Now we'll discuss the subtleties of the way in which Daily Mail is retained in a little while. So Daily Mail suggested that companies could not benefit from mobility as a matter of EU law, that this was a matter for the laws of the member states to resolve and future secondary legislation of the European Union to resolve. But matters changed through the judgment in Centros. Now, Centros, which is case 212 of 1997, marks a change towards a more liberal approach to the mobility of companies. And the approach of the court is best summed up in the opinion of Advocate General La Pergola, which preceded the judgment. Now, La Pergola basically says in his opinion that the right of establishment is essential to the establishment of the internal market, and that freedom of establishment guarantees the freedom to engage in business through any of the instruments provided by national law. So effectively, what follows from this, in A.G. La Pergola's view, is that promoters of companies should be able to choose any of the instruments provided in the legal systems of the member states. They should benefit from contractual freedom to choose the laws of any member state. Now, the facts in Centros concerned a Danish couple who wished to establish a company physically in Denmark, but to use UK law to do this. And the reason they wanted to use UK law which they admitted freely, was that they wished to benefit from the more accommodating minimum capital requirement rules under under UK law. And effectively what they wished to do was to avoid Danish minimum capital requirements. Advocate General La Pergola suggested that they could do this, and on this occasion the court accepted his views. So in Centros it was held that member states must recognize companies established under the laws of any other member state, and this was confirmed in the judgment in Uber-Searing, case 208 of 2000. So Centros and Uber-Searing established the principle that Articles 49 and 54 require member states to recognize companies or firms formed in accordance with the law of a member state and having their registered office, central administration, or principal place of business within the Union. So effectively, Centros and Uber-Searing establish a market for company laws in the European Union. They require member states to recognize companies even if the rules of those member states previously would require those companies to be governed by a different national law. The thrust of liberalism established in the Centros judgment was confirmed further in a later judgment in Inspire Art, case 167 of 2001. And in this case, it was held that if a company is established under one national law, another member state may not impose further obligations on that company. So effectively, this ensures that there is indeed a market for company laws, and that member states cannot distort that market by imposing further requirements on companies that are established within their territory but governed by a foreign law. In Civic Systems, a case that was lodged with the court in 2003, the thrust of liberalization is taken even further, where the court held that cross-border mergers could not be must be recognized by the member states. Now, effectively, what the implications of civic systems are that member states must allow cross-border mergers, and as a consequence of this, a company can change its governing law. Now, how would you do this? You do this by establishing a shell company in another jurisdiction and then merging with that shell company and dissolving the original company. So effectively, this is what's called a reverse vertical merger, where the existing company is dissolved and a new company is established in another jurisdiction. So it's effectively a two-step change in the governing law. Now, since civic systems, the cross-border merger directive has been adopted, which we discussed earlier, and there are now conditions governing cross-border mergers, which include, as I said, protection of certain stakeholders. But up to here, what we see is that there is still the Daily Mail judgment, which restricts the ability of a company to embark on de facto emigration to another member state, while not also without de jure emigration. But there certainly then is a change in the approach from Centros onwards, where we see that the court is adopting a liberal approach, allowing promoters of companies to choose the governing law and restricting the ability of companies, the ability of member states to govern the activities of companies established by the laws of other states. Now it seemed at this point that we had several liberalizing judgments, but that Daily Mail sort of stuck out like a sore thumb, and the court was invited to consider the Daily Mail ruling again in the judgment in Cartesio. In Cartesio, a Hungarian limited partnership wished to transfer its headquarters to Italy, but to remain governed by Hungarian law. So this was very similar to the situation in Daily Mail, where we have effectively a de facto seat transfer without a de jure transfer. So the company wished to change the situation of its seat, but not change its governing law. Now the court held here again, as it did in Daily Mail, that it is for the member state under whose laws a company is established to determine where that company must have its seat. So mobility is restricted here to the extent that a company cannot change the situation of its seat without also changing its governing law. And the court suggests in an obiter dictum in this case that if the company wished to also change its governing law, then Hungary in this case would not have been able to stop the transfer of its headquarters. So the suggestion in Cartesio is that de jure and de jure mobility accompanied by de facto mobility cannot be restricted by the member states, provided, as you see in the last line, that this is permitted under the law of the destination state. So in this case, if Italy allowed Cartesio to move its headquarters to Italy and to also convert to an Italian partnership or company, then Hungary could not stop Cartesio from doing this. Now, what's interesting about this judgment is this last line, which I've italicized, the words "to the extent that it is permitted under that law to do so." It isn't clear here whether Italy would have had an obligation to accept the conversion of Cartesio from a Hungarian partnership to an Italian partnership. This matter was resolved in a judgment from last year in the case of Vale. Now, Vale was an Italian company that wished to become a Hungarian company, to convert from an Italian company to a Hungarian company while retaining its legal personality. Effectively, the issue was the exact same issue identified in the obiter dictum in Cartesio. And the question here was whether Hungarian law could restrict the change in could restrict the ability of the Italian company to become a Hungarian company. And effectively the problem was that Hungarian law did not provide for this. It provided for conversions of Hungarian companies, but did not provide a framework for the conversion of foreign companies into Hungarian companies. And Hungary argued that there was no obligation for it to allow the Italian company to become a Hungarian company, because the obiter dictum in Cartesio suggested that this ability depended on the laws of the member states. But the court held that this obiter dictum in Cartesio did not actually mean what it appears to mean in such simplistic terms, and that companies can in fact transfer from one member state to another if the national law allows domestic companies to transform from one corporate form to another. Effectively, the conclusion here is that companies may change their governing law in a single step. So in civic systems and in the cross-border merger directive, it was established that a company could choose to change its governing law by establishing a foreign subsidiary and then merging with that foreign subsidiary. In Vale, it is established that a company can actually change its governing law in a single step. Of course, this is subject to some conditions that we'll discuss in a little while, but it certainly is not subject to a European legal instrument. There is no directive on the cross-border transfers of companies, and therefore, unlike cross-border mergers, cross-border transfers operate in a somewhat hazy environment, because we don't know what conditions member states can impose on cross-border transfers. We don't know whether the interests that are protected in cross-border mergers can be protected by national laws in cross-border transfers, and we don't know, and there isn't an administrative framework for this to happen in. Now, effectively, therefore, what is the current situation? Companies at present can be established in any member state, and subject to the conditions in Article 54, they must be recognized throughout the entire European Union. The member state where a company has its headquarters cannot impose further obligations on those companies simply because they're established under foreign law. Those member states simply cannot interfere in the internal arrangements of those companies. They must be recognized as established under foreign law. And that is the rule established in Inspire Art. We also know that companies may merge with foreign companies, and this is the rule established in Civic Systems and confirmed in the Cross-Border Mergers Directive. So companies can engage in a two-stage change in the governing law of that company through a reverse vertical merger. Through the judgment in Vale, we also know that companies can now change their governing law in a single step. There is no regulation governing this matter, although there is some movement towards the adoption of a 14th Company Law Directive on cross-border seat transfers. Finally, however, all of the above is subject to the principle that remains established in Daily Mail and Cartesio, which is that a company must remain in good stead with the law of the state in which it is established. So if, for example, as in the case of Cartesio, Hungarian law requires that all Hungarian companies must have their physical headquarters within Hungarian territory, that must be respected by companies established by Hungarian law. This matter is not within the scope of the treaty as currently understood by the Court of Justice of the European Union, and it follows that therefore there is some limit to cross-border mobility, effectively because you cannot choose the law of certain states if those laws require that you must situate your headquarters in their territory, unless, of course, you wish to have your headquarters in that particular territory. Now, that brings me to the end of this brief presentation. I hope that was interesting to you, and I'd be happy to receive any questions by email. Thank you.